This application for bail was brought under the relevant provisions of the law. So I don't have to repeat. We have those copies. The application seeks the following order: that the applicant accused is granted bail pending the hearing and disposal of criminal case number 43 of 2023. The grounds of the application are contained in the affidavit of the applicant, and briefly are that the applicant is charged with the offense of murder of her husband, Molly Katanga, contrary to Section 188 and Section 189 of the Penal Code Act. The applicant is entitled to the presumption of innocence until proven otherwise. That on the 24th of January 2024, the applicant was arraigned before the Chief Magistrate's Court of Nakawa at Nakawa, and on the same day she was committed to the High Court for trial. The thing is too sensitive, eh? Let's not put it so close. I know it can capture. I'm used to this microphone. So, prior to being committed to the High Court and her being remanded to women's prison, the applicant had spent over 2 months at CKR International Hospital, Kampala, where she was receiving specialized treatment and underwent 5 major surgeries to her scalp and her hands to address the injuries she sustained on the 2nd of November 2023. But the applicant's physical condition is still frail due to the injuries she sustained and is still suffering from post-traumatic stress disorder, hypertension, vertigo, and breast fibrocytic disease. As such, the applicant requires regular access to specialized treatment and supervision, and that the applicant is of advanced age, that is 55 years old, and requires specialized medical care due to her current medical condition, and that the applicant has substantial disease that will ensure her court attendance at all times, as well as her compliance with the bail terms that shall be set by the court. And the applicant has at all material times been a law-abiding citizen and has never been charged and or convicted of any criminal offense. And the applicant has a fixed place of abode at Mbuya 1, Mbuya Hill Village, that is in Nakawa Division, Kampala District, within the jurisdiction of this court. And the applicant is gainfully employed with the sole breadwinner of her family and the mother of a child of 10 years who is totally dependent on her. The applicant will not interfere with the prosecution witnesses. The respondent opposed the application through an affidavit informed by Detective Assistant Superintendent of Police Congo Bibiana, which states that the hearing date for the main case has already been fixed for the 2nd of July 2024, that during the applicant's stay at CKR Hospital, she was under a private arrangement for protection by officers of the Special Forces Command attached to one Geoffrey Kamotu that impeded or obstructed police investigations and made it difficult for police to access the applicant, that the said Geoffrey Kamotu is being presented as a surety in this application is investigation is for obstructing the police from doing their lawful duty in relation to this matter, that by the time the applicant was arraigned in court, she had been fully discharged from hospital, that the applicant has previously shown by her conduct that she is incapable of honoring court process, having dishonored court summons issued in the presence of her lawyers, and that the applicant only appeared in court upon arrest following a warrant of arrest by the Chief Magistrate's Court of Nakawa. The applicant also filed two affidavits in rejoinder, whose averments were challenged by way of a criminal objections raised by the respondent during the hearing of the application. I'll first consider them. The parties also filed written submissions which are on record and shall not be reproduced here, but I will refer to them where necessary. It is the contention of the respondent that there are some of the averments contained in the affidavits I referred to above offend the law applicable to affidavits set out under Order 19 Rule 3 of the Civil Procedure Rules, but the argumentative, contain hearsay, narrative, conjecture, and apologies. It is also contended by the respondent that some averments contain falsehoods and are incurably defective. Cited the case Mabirizi Mare versus Attorney General to support this case. The respondent referred to paragraphs 5, 7, 8, 10, 11, 12, and 15 of the affidavit in rejoinder deponed by Geoffrey Kamuntu, and paragraph 3A to B of the affidavit in rejoinder shown by one Augustine Billy Idot. I have carefully considered the preliminary objections by the respondent, and the council's submission is for and against the same, guided by the cited authorities and the relevant law. The applicable law relating to the affidavits is under Order 19 Rule 3 of the Civil Procedure Rules, provides matters to which affidavits should be confined. They should be confined to such facts as the deponent is able of his own knowledge to prove, provided that in interlocutory proceedings or by leave of the court, an affidavit may contain statements of information and belief showing the sources and grounds thereof. Further, under Order 19 Rule 3.2, it is provided that the costs of every affidavit which shall unnecessarily set forth matters of hearsay or argumentative matter or copies of all extracts from documents shall, unless the court otherwise directs, be paid by the party filing the same. In dealing with affidavits of this nature, where the deponents are neither witnesses or accused person, it is important to consider the context of the averments before reaching the conclusion that an affidavit is argumentative or prolix. In this case, I have considered the context of the impugned averments, and they are basically a response to the averments contained in the affidavit in opposition to the bail. They are specific averments made and are relevant for purposes of pleading and are also within knowledge of the deponent. A case in point is the paragraph in relation to an agreement allegedly executed by the applicant's family, the police, and the CKIHK International Hospital with regard to who could access the applicant. The document bears the names of the person is in attendance. The document is also bears the stamp of the Director of Health Services of Aged Care, and is dated 21st of November 2023 and is signed by Dr. Kavuma. It is therefore clear that this document was authored by the hospital and was executed in the presence of all the concerned parties. The respondent also referred to paragraph 10 of Geoffrey Kamuntu's affidavit in the rejoinder. It contains that it is argumentative, narrative, prolix, and is therefore inadmissible. The paragraph refers to an incident where the deponent was allegedly put on gunpoint for taking pictures of police officers at the theatre. I have looked at the impugned paragraph and I find that it is not argumentative. It is a response to Averment 3E of the affidavit in reply. A preliminary objection of this nature cannot be raised because objection requires ascertaining whether indeed the incident happened. It will also require further evidence from Aged Hospital. I have also considered the other impugned paragraphs and I find that the response to the assertion is contained in the affidavit in opposition to the application. Now I go for the merits of the application. The law applicable to bail was properly laid out in the case of Uganda, that is the DPP versus Colonel Dr. Kizabesije, Constitutional Reference number 20 of 2005. It was held that an accused person has a right to apply to court to be released on bail, and the court has the discretion whether or not to grant bail. The same is emphasized under Article 23, Sub-Article 6A of the Constitution of the Republic of Uganda, which provides that the person is entitled to apply to court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. While the right to liberty and presumption of innocence are vital, the court must also consider the gravity of the offense, the impact it has on society, and the interests of justice in general. The court's discretion in weighing these interests upon specific facts and circumstances of the case become crucial. The court must therefore strike a balance between the two. In Mwaza Kroma versus Uganda, that was in the criminal division in 2017, the court observed that whereas Article 23B of the Constitution of Uganda provides that a person whose liberty has been deprived by imprisonment before trial, even not serving a sentence, be free to apply to bail. The court must give adequate and appropriate consideration to the rights of the applicant, the respondent, and the society as a whole while exercising its discretion. Rule 5 of the Constitutional Bail Guidelines for Courts of Judicature Practice Directions of 2022 also provides that the court shall, in considering a bail application, be guided by the following principles as enshrined in the Constitution. A, that the right of an applicant to be presumed innocent as provided for in Article 28, 3A of the Constitution. B, the applicant's right to liberty as provided for under Article 23 of the Constitution. And then C, the applicant's obligation to attend trial. D, the discretion of the court to grant bail on such terms and conditions as the court considers reasonable. Then E, the need to balance the rights of the applicant and the interests of justice. All these are contained in the Rule 5 of those guidelines. Furthermore, Section 15 of the Trial on Indictments Act provides for other considerations such as proof of exceptional circumstances, which include infancy, advanced age, grave illness, and a certificate of no objection from the Director of Public Prosecutions. Although it is no longer mandatory for an accused person to prove exceptional circumstances, an accused person who establishes exceptional circumstances stands a better chance of being granted bail if he or she can satisfy the court that they will not abscond or prejudice the admission of justice if granted bail. See the case of Nyanzi Yusuf Siraj versus Uganda. It is the contention of the applicant that her physical condition is still frail and due to the injuries sustained, and that she is still suffering from post-traumatic stress disorder, hypertension, vertigo, and breast disease, and as such, she requires regular access to specialized treatment and supervision. The applicant also contends that she is of advanced age, that's 55 years of age, and requires specialized medical care due to her current medical condition. It is contended by the applicant that her condition demonstrates or proves existence of exceptional circumstances. The respondent, on the other hand, strongly contested the fact that the applicant's condition cannot be managed by the prison authorities. It was submitted that the prison authorities did not issue any report to certify that the applicant's condition cannot be managed in the prison's medical facilities. Section 15 subsection 3 of the Trial and Indictments Act defines exceptional circumstances as follows: grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody. 2, a certificate of no objection when the director of public prosecution is or infancy or advanced age of the accused. From the reading of section 15 subsection 3(1) of the Trial and Indictments Act, the only medical officer who is authorized to examine an accused person for purposes of securing bail under exceptional circumstances is a medical officer of the prison or place where the accused person is detained. Again, this one, we refer to the case of Onebe Francis versus Uganda. Section 15 subsection 3(1) of the Trial and Indictments Act defines grave illness as an illness that is incapable of adequate medical treatment in the prison. Be satisfied that the prison's medical facilities are incapable of treating or managing the accused's illness with positive outcomes consistent with existing medical standards. The first report in relation to the applicant's condition is marked Annexure A1 and is signed by A1 Dr. Patrick Sekimpi. It is dated 13th of November 2023. The other report on record is as of the 3rd of January and is signed by A1 Dr. Joel Chiriabwire. All these reports are from CKIHK Hospital. The purpose of the above reports was to assess the applicant's ability to record a statement as shown by the correspondences. The other report on record is a discharge summary and is dated the 24th of January 2024. There is also evidence that the applicant's counsel requested for a comprehensive medical examination of the applicant by the prison's authorities for purposes of applying for bail, and the prison's authorities responded by forwarding the letter to Mulago Referral Hospital. Indeed, the examination was carried out by a team of specialists from Mulago Hospital. The said report is dated the 8th of February 2024. While the report contains various observations with respect to her health and condition, it falls short of stating whether the condition cannot be managed in prison. The law is clear. The only medical officer who is authorized to examine an accused person for purposes of securing bail under exceptional circumstances is a medical office of the prison or place where the accused person is detained. Further, the medical officer must certify that the condition of the accused person cannot be managed in prison. I perused all the medical reports on record, and there is no such evidence. Accordingly, the absence of any certification from the prison is that her condition is grave and cannot be managed while she is in prison. This ground cannot succeed. On the question of advanced age means the person who is 60 years of age and above. See Rule 4 of the Constitution, Bureau Guidelines for Courts of Judicature, Practice Directions of 2022. The applicant's age is stated to be 55 years. As per the rules, it cannot be said that she's of advanced age. It is important to consider whether it is in the interest of justice to grant the application. The court must weigh the gravity of the alleged offense and all other factors of the case. In the application, the applicant has already been committed for trial. The matter has also been fixed for trial. The court does not envisage any likelihood of delay. Though the sureties in this case appeared substantial, the above findings dispense with the need for them in the matter. Having considered all the circumstances of this case, and in view of all the foregoing, it is my view, considered view, that the application for bail is denied. The ends of justice would instead be best served by hearing the main case. Accordingly, the application for bail is dismissed. Since the case has been already fixed for trial, the parties are advised to prepare for the trial. I so find.
But what can you say following the judgment?
No, I have no words. I'm so grateful. I thank God. We serve a mighty God. It's the supreme judge we serve. I have no words. I just glorify his name. Because the judge, I don't know. I don't know the judge. I know the supreme judge, the God we serve.
The name?
Now Menyangweso, the sister to the deceased.
About the judge's ruling.
It's fair.
Yes.
It's fair. He balanced all the interests. The interests of the accused person, the interests of the society, the need to serve justice. And he said instead of granting bail, he'd rather the trial goes on expeditiously.
Why do you say that the interest of the public, if you talk of interest of the public?
Well, you have seen the public outcry. The public wants justice to be done. And justice is done by trying the accused person and finding out whether she's guilty or not. But not merely releasing her when there are those grave allegations. No, omulamuzi asaze bulungi kubanga yatadde mu nkola ndowooza n'ebiteekateeko by'abantu amateeka kyegogera ate ne interest za omuwawaabirwa n'agamba nti omuwawaabirwa interest ze ziri served by okuwulira omusango ogwo mangu n'olwekyo settle date y'okuwulira omusango. Ekyokubiri n'agamba nti abantu public mu Luganda public ki abantu balina endowooza yaabwe. Omusango guno gwamaanyi bwe guti tomulagalekula muntu okujjako ng'omutrayinze n'olaba nti teyakikola n'olwekyo okusasifayinga endowooza z'abantu nanga nti abeereyo okusavinga interest of justice trial ebeere mangu nnyo bw'abanga teyaza musango bwamute bwanga yaguza.
Kanso yogera ki ku kyokubeera nga hearing egenda tandika nga gwali ku state good watching brief. What can you say? Are you people set? Your team, are you set?
The DPP is set. I am sure the DPP is set. The evidence is there to the best of my information. Ubujuzi bwe buli bari ready, turi ready ogenda maaso n'omusango katugende mu maaso n'omusango guwulirwe bw'abanga teyaza musango bamute ffenna tusanyuke bw'abanga yaguza bamusibe ffenna tusanyuke.
Thank you.
Council Edson from